This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about why taking the profit out of fraud is and always will be effective, and why GEICO continues to sue allegedly fraudulent healthcare providers, because it saves them money. A subpoena issued by GEICO to the state prosecutors was to be an effective way of gaining additional evidence to prove the health care providers being sued committed fraud. And of course, defendants Todd Koppel, M.D., and Garden State Pain Management, P.A., collectively referred to as the Koppel Defendants, moved the United States District Court to quash a subpoena issued by GEICO upon the New Jersey office of the Insurance Fraud Prosecutor, the OIFP. In In-Ray Government Employees Insurance versus Todd Koppel et al., the U.S. District Court for the District of New Jersey on August 28, 2023, dealt with the right to subpoena the prosecutor's files. Plaintiffs sued the Koppel defendants, alleging that they unlawfully obtained personal injury protection, or PIP, benefits from plaintiffs by making false representations as to their compliance with New Jersey law, when in fact they were operating in violation of New Jersey law by paying kickbacks to chiropractors in exchange for patient referrals. Based on these allegations, the plaintiffs asserted claims against the Koppel defendants pursuant to the New Jersey Insurance Fraud Prevention Act, the IFPA, the Civil Racketeer Influenced and Corrupt Organization Act, or RICO, and common law fraud and unjust enrichment. The subpoena sought a copy of all criminal investigative records from the OIFP's Medicaid Fraud Control Unit concerning the Koppel defendants. The Koppel defendants filed a motion to quash the subpoena, arguing that the information sought was irrelevant and that the plaintiffs failed to show a compelling need for the requested information, which is privileged under New Jersey law. Alternatively, the Koppel defendants requested entry of a protective order to prevent discovery of the Koppel defendants' investigative files held by the OIFP. The court noted that the defendants' challenge to the subpoena was based on relevancy, privilege, and undue burden. A party, however, lacks standing to challenge subpoenas issued to a non-party based on those grounds. The court found that the defendants lack standing to challenge the subpoena on the grounds of relevancy and undue burden because the relevancy and undue burden was upon the OIFP, not on the defendants. In addition, the defendants failed to convincingly articulate why the information that is subject to the subpoena is irrelevant or how its production would be unduly burdensome. To the contrary, the court noted that the information plaintiffs sought overlaps with the allegations in the complaint and is therefore relevant. Conversely, the Koppel defendants do have standing to challenge the subpoena based on their claim that the records are privileged under New Jersey law. Some statutes allow that confidentiality of the information and materials in the possession of the OIFP shall not preclude OIFP from coordinating and providing information to and among referring entities on pending cases of suspected insurance fraud where such action would serve the public interest in facilitating the investigation or prosecution of insurance fraud. Moreover, the IFPA specifically addresses disclosure of OIFP investigatory files to insurers such as plaintiffs. The discretion of the insurance commissioner controls whether the records sought by the plaintiffs remain privileged. It is not a privilege that belongs to the Koppel defendants themselves. The OIFP did not join in the Koppel defendants' motion, nor did the OIFP seek to quash the subpoena independently. Because the OIFP's only objection to disclosure is the lack of a court order, the USDC found that the subpoena does not necessarily hinder the OIFP, and the records may be disclosed. Therefore, the Koppel defendants' motion to quash was, as a result, denied. The Koppel defendants also failed to meet their burden to show that good cause exists to issue a protective order. Accordingly, the Koppel defendants' alternative request for a protective order was denied, and the subpoena was issued, and GEICO will receive those documents. In my opinion, GEICO should be honored for its proactive acts against insurance fraud by taking the profit out of insurance fraud, since very few such fraudsters are arrested, tried, or convicted. Although the OIFP did not prosecute the Koppel defendants, they collected information that will invariably assist GEICO in its efforts to obtain damages and fines from the Koppel defendants, who they believe defrauded GEICO, because GEICO only needs to prove the fraud by a preponderance of the evidence, while the OIFP needed to prove it beyond a reasonable doubt. Taking the profit out of fraud is more effective, in fact, than prosecution of fraudsters for crime, and will support, when GEICO eventually succeeds, the efforts of the OIFP to prosecute other fraudsters. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. If you found this video or the blog posting to be of interest, please tell your friends and colleagues so that they too can subscribe to the blog and the videos, all of which is free, and will gain them access to the more than 4,600 blog postings and the more than 700 videos. If you and your friends and colleagues wish more detail about insurance, insurance law, and insurance fraud for a very small fee, you can subscribe to my Substack publications or my Locals community. Thank you for your attention.